how many of you here are aware of the K.S. Puttaswamy judgment, right to privacy, Aadhaar?
Thank you.
So last year, after a very long battle of 5 years in K.S. Puttaswamy versus Union of India, the Supreme Court held that we have right to privacy, which is embodied under Article 21. So while people were primarily, it was right to privacy which was being interpreted with regard to our social security and the benefits that arise out of the UIDIA number and Aadhaar card, but also Justice Mishra, Deepak Mishra, who was the then Chief Justice, he wrote considerably on how right to privacy is also going to affect Section 377. And on September 6, 2018, 377 was decriminalized, right? So yesterday, everybody was celebrating that how it's been 1 year of 377 being decriminalized and how that's a landmark judgment on its own. So then the interpretation that Justice Deepak Mishra gave was that 377, now you have something called right to privacy, and what two people or two or more people do in their personal life, it cannot be something that the state has any interference. And hence, what we come to now is, see, this bill only arose out of one litigation that we did. Criminal Justice Society of India, as you heard that the two of us work in it, and this is basically just a lawyers collective where Mr. K.T. Tulsi is the president. So you guys are aware of the definition of 375 and 376, 377 by and large, or should I go through with it? Yeah. So they are basically 7-8 changes that we proposed in this bill, but once we cumulatively read the K.S. Puttaswamy judgment and decriminalization of 377 in Navteej Singh Johar, what emerges is something which is, it's actually, there's a huge disparity in law which is created consequently. So over here, okay, you guys are also well aware of the fact that the Justice Verma committee came out with a report. So if I may just use the board to just illustrate, a timeline for you guys. So in 2000, the Law Commission report came out with the 172nd report. What this report said was that rape is something and sexual offences are something which both the genders face alike. And they said there should be gender neutrality of law. So they said that in two aspects. One was for adults and one was for children. But they saw that, in fact, when it comes to children, there are more boys who are sexually assaulted than girls. So this led to actually what we know as the POCSO Act, the Prevention of Children from Sexual Offences. That arose out of the 172nd report. Even though they made one suggestion about that how the sexual offences, especially rape, has to be gender neutral, and consequently if rape is made gender neutral under 375, then 377 has to be deleted, because that means to show that whatever is non-consensual carnal intercourse under 377, that will be gender neutral, and hence we won't need 377 for human beings, but it will remain valid for bestiality. At any point, if you have any confusion, please feel free to ask. So over here then POCSO came into the being, but this is the legislation only for children, for under 18. Then henceforward, we come here in 2012, in December, there was this one bill which was introduced by the Home Minister in the Lok Sabha, and that was to make, that was also a criminal law amendment bill to make rape gender neutral. So this bill was introduced but in the meanwhile, as we all know, in December 2012 itself the Nirbhaya rape took place, and that shook the nation. As a result, the Justice Verma committee was appointed. That was 23rd December 2012. The Justice Verma committee was appointed. And exactly in 30 days, in January 2013, their report came out. Now, what this report said was that we can make rape gender neutral from the aspect of the victim, but not the perpetrator. So that is why the definition of rape is very important to know. It says a man is said to commit rape on a woman if, and then they list out the instances. So as per that, it means only a man can be a perpetrator and female can only be the victim. But this report said that let the victim over here be made gender neutral, but the perpetrator can only be a man, only a male can be the perpetrator. Henceforth, what happened to this bill in the meanwhile, that now Parliament session was over by then. So by the way of a criminal law ordinance of 2013, for 58 days in the country, the rape laws were gender neutral. So consequent to this, this ordinance came into the being while the Parliament of course was in recess. Right? But of course, right now, all the protest and the focus was on the Nirbhaya rape and the statistics of all this domestic abuse and sexual abuse against women. So after the protest, the criminal law ordinance lapsed, and then came the Criminal Law Amendment Act of 2013, which restored the position of male being the perpetrator and the female being the victim. Right? So this is in 2013, and this is around June, July, when the Parliament comes back into session, right? Now we come down to, of course, what we've discussed, K.S. Puttaswamy, where the implication of right to privacy on sexual offences was drawn. And in the meanwhile, we also had Navtej Singh Johar, consequent to Puttaswamy. Now I'll go back and read 377 and 375 with you. So the definition of 375 is, a man is said to commit rape if, now subclause A is, penetrates his penis to any extent into the vagina, mouth, urethra or anus of a woman, or makes her do so with him or any other person. B is, inserts to any extent any object or part of body, not being the penis, into the vagina, and so and so. So first is the penis, then it's any other object. Thirdly, it's manipulates any part of the body of a woman, and D is, applies his mouth. So if you see what has happened pursuant to the 2000 report, that the definition of what is penetration under 375 also enlarged. It was no longer penile vaginal orifice. It went into mouth, any other object, and manipulation also. Now, if 377 consensual is no longer an offense, then what is non-consensual carnal intercourse against the order of nature? Nobody knows, because there is no such definition, there is no interpretation of it. All it says is that carnal intercourse means anything that you're not, which is not penile vaginal and which is not done for the purposes of procreation. So any recreational sex, it's 377 was largely misinterpreted for this. It was not a homosexual or a gay law, anti-gay law. This also affected heterosexual couples alike, but it was just so called the gay law. So now if consent is again something which is not present in 377, does anybody know the definition of how 377 reads or read? So it's basically whoever voluntarily has carnal intercourse against the order of nature with a man, woman or animal shall be punishable with imprisonment of 10 years up to 10 years up to life and with fine. So minimum is 10 years in that. Now again, it says voluntarily. Consent is not there. And people were previously being booked in 377, whether you were the victim or the perpetrator, both of them would be booked under 377. So after the judgment of Navtej Singh Johar, you realize there's a huge gap in law, because it says that only to the extent now you have something called consensual and non-consensual. Right? But consent and voluntarily are two very different things if you see in interpretation of statutes. So what we realized when we were discussing, I remember that morning Mandakini and I were sitting in front of Mr. Tulsi and we were reading both 377, 375 with Navtej Singh Johar, and what we realized that if the definition of rape is so enlarged that it's moved away from penile vaginal orifice, then doesn't non-consensual amount to rape here? Because it's the same thing. Unless and until you are able to say that what is carnal intercourse against the order of nature, we don't see any intelligible differential of having one 377 and having one 375, which by and large is the same, only that over here in 375 you have minimum 7 years, here you have minimum 10 years. And plus the victimization which a rape victim and the sensitivity that you have and the procedure that you follow under 114A evidence, all that is not very similar in 377. And then we moved to the Supreme Court with the public interest litigation under the banner of Criminal Justice Society of India. We challenged 375. And of course at that time, in the first hearing itself, it was Justice Ranjan Gogoi, he said that we understand that there is some validity in what you are saying, it's a valid point that you are raising, but this is because in 2000 there was a recommendation by the Law Commission, you go back to the Parliament, and for now we will not interfere. So even all this while, in 19 years, if the Parliament really hasn't considered, apart from this brief period of 858 days, to make the rape laws or sexual offence laws in the country gender neutral, but yet the courts did not want to interfere solely for the fact, he said, there are no statistics. So you can find a lot of stats of women being raped, children being raped, but if you Google and you say, or you are supposed to have any report on this, that how many males and of course transgender persons, how many of them are raped.
Earlier the complaints weren't even brought
Yeah, so that's the thing. When you go to the police station to report your complaint, if you don't have a valid section in the penal laws, the police officers are just going to shoo you away. I'm sorry, there's one thing which he reminded me. I forgot. Back here in 2015, we had Nalsa's judgment, which gave transgender persons the right.
That includes eunuchs and
So even though in our country the definition of transgender is largely limited to eunuchs, though worldwide if you see there are 63 kinds of genders. So this is important for you to understand, because when I just go over a few sections in the bill, you will understand why the thought process emerged this way. So as a result, Justice Gogoi's only question was that where are the statistics on this? But it's very difficult to get stats on something which is not even
acknowledge.
a penal offense. In under what section will they be booked? That would be 377. And again 377, both the persons, whether you're the victim or the perpetrator, you get, because over there voluntariness, you can't prove that somebody came and forced me into it, because again 377 doesn't allow for it. It doesn't say whoever's been forcibly been dealt with under this situation. So that was the gap in law over here. So this till now was after that. In Criminal Justice Society of India, we got the liberty to move the parliament with the bill. Yeah, so Tulsi sir, of course, as I mentioned, he's the president of this society.